We will get started now. So hello and good morning, everyone. Thank you for joining us for today's CAS webinar on when, what, who, and why, the perils, pitfalls, and parameters of mandated reporting, presented by attorney Michael McKeon from the law firm of Pullman Comley. I'm Bill Silva, Associate Executive Director at the Connecticut Association of Schools, and I'm pleased to have so many signing on for this timely presentation. Before I introduce Attorney McKeon, I want to thank our corporate partners, the Connecticut Army National Guard, Liberty Bank, Horace Mann, Jostens, Connecticut Lighting Centers, the Connecticut Department of Public Health, and of course, Pullman and Comley, for their ongoing support of CAS's high-quality professional development for school leaders and all educators in Connecticut. I also want to go over how we will proceed today. During the presentation, you in the audience are muted, but you may share any questions you have using the Q&A feature, and our presenter will try to answer as many questions as he can during the hour and a half that we have today. We are also recording the webinar, and we will make the recording available to you in the next few days. And now let me introduce our distinguished presenter. Attorney Michael McKeon is a member of the school law section of Pullman and Comley's Labor, Employment Law, and Employee Benefits Department. Attorney McKeon represents boards of education and other clients in both federal and state courts at the trial and appellate levels, as well as before federal and state boards and commissions. Attorney McKeon has presented on a variety of education law issues, including special education law, gender equality in student athletics, and both gender and disability-based student harassment, and he regularly conducts training for school personnel on sexual harassment and education law issues. Attorney McKeon has served as adjunct professor at the University of Connecticut School of Law and in the University of Bridgeport's Department of Education doctoral program. A graduate of the University of New Hampshire and the University of Missouri, Attorney McKeon received his law degree from the University of Connecticut School of Law. So welcome, Attorney McKeon. We are pleased to have you as always. Look forward to you being here and also look forward to the information that you have to share today. So I will turn the presentation over to you.
Thanks, Bill. I appreciate it. Good morning, everyone. Thank you for tuning in, so to speak, on this topic. You know, it occurred to me listening to Bill, very generous introduction. I guess I had something of a, I don't know if it was a Freudian slip or what, because yes, the original title was Perils, Pitfalls, and Parameters of Mandated Reporting. But I realized, listening to Bill, that when I put together the slide, they just had the Perils and Pitfalls. We'll also talk about the parameters, but when one thinks of mandated reporting and the obligations, very often perils and pitfalls come to mind. It's interesting, public schools, private schools as well, but more so even public schools, just because they are public actors, they're public sector bodies, they also have a constitutional overlay. In other words, they are also dictated by constitutional provisions such as free speech and search and seizure and so forth. But public schools are really probably one of the most highly regulated entities in the state of Connecticut. There's a plethora of federal laws, and there's an equally prodigious body of state law. Connecticut has legislators that just love to enact laws. And so it's very easy. There are a lot of tripwires out there because of all these laws. And it's very easy sometimes to run afoul of them, primarily, inadvertently, one hopes. But for the most part, if they do, there are consequences. But few enactments have a consequence of potential criminal prosecution, which is a part and parcel of Connecticut's obligation of mandated reporting of suspected child abuse and neglect cases. And that's, again, why perils and pitfalls are the two words that most readily sprung to mind. Having given that kind of ominous beginning, I will go from there. As I'm sure you all know, the Connecticut law requires certain categories of individuals that report suspected child abuse and neglect. They're known as mandated reporters, and they They really are. I mean, the statute actually enumerates what these different categories of occupation are. And what's most relevant, I think, to the presentation today are the mandated reporters that work for schools. I mean, doctors and other non-educational people are also identified by statute. But again, the focus of this is obviously on school employees. And you'll notice throughout this presentation, and for those of you who also attended the webinar on student discipline that I did in January, I love colored font. Anyway, as you'll see, any school employee is considered a mandated reporter. So it's not just the central office administrators, it's not just the building administrators, the certified professional staff, it's everyone. Furthermore, any person holding or issued a coaching permit by the State Board of Education, who is an intramural or interscholastic athletics coach and is 18 years of age or older, in other words, who's deemed an adult under the law, they're also considered to be mandated reporters. So I break that down a little bit more here. I guess the word any in the prior slide probably covered all this, but lawyers, what's the old saying? Lawyers say wear belts and suspenders both. So I wanted to set forth all the different categories. And I might not have listed each and every actual employee, but I think you get the drift. The second paragraph on the slide is kind of interesting. Any other person who in the performance of his or her duties has regular contact with students and who provides services to or on behalf of students enrolled in a public or private elementary, middle, or high school pursuant to a contract with the school. I think it's pretty interesting, the pursuant to a contract, because one of the questions is, if you're a volunteer, for instance, for, oh my God, many, many years, I volunteered as a coach for a high school mock trial team. I don't get paid for it. It's just something that I've done just as a volunteer. I don't have a contract with the school. I just do it. The question is, would I fall within the category of mandated reporter? From the express language of the statute, I presumably would not. Nonetheless, I like to think that if I saw something inappropriate, I would report it, perhaps. But in any event, again, this talks about those entities or individuals who are brought in by contract by schools. They noted there are also some non-school mandated reporters, police officers, behavior analysts, which are commonly known as BCBAs, nurses, drug counselors, marital and family therapists, so forth and so on. And this kind of ties into what I was just saying before. As is clear from these two prior slides, professionals who provide related services, such as physical therapists, speech pathologists, occupational therapists, social workers, BCBAs, behavior therapists, they're not board employees necessarily, but they're working into the schools under a contract. I think of like Aspire, it used to be known as IPPI, that provides behaviorists to a lot of school districts. Obviously, there are other entities as well who do the same thing. There are speech and language pathologists or occupational therapists, physical therapists with whom districts contract. These individuals, because they're in the school, because they have contact with students, because they are under contract, they would also be deemed to be mandated reporters. And I think, I noted it's professionals who provide related services. And, that sounds a little hoity-toity, but I think also, again, given that prior slide when it talks about individuals who have, let me go back to it for a second, who in the performance of their duties has regular contact with students and provides services to or on behalf of students by way of a contract. Given that definition, I think that would also apply to let's say the school district does not have its own school lunch program, many, most, if not most, do not, but they contracted with, some outside entity to come in and provide lunch service. Now, whether they are, the lunch people are district's employees or their employees, let's say they're their employees, the performance of the duties takes them into the school. They have interaction with students. They might only be at the end of a ladle, but nonetheless, they have regular interaction with students. And they're doing these duties pursuant to their company's contract with the school district or with a private school. So I would say that this mandated reporting obligation would also extend to them. There are certain types of statutes that are enacted by the legislature. Some of them are, for instance, and they're treated differently. For instance, criminal statutes, they're required to be construed narrowly. And that is to protect the constitutional rights of the accused. Then they have what they call remedial statutes. Remedial statutes are those, well, like for special education and mandated reporting. Remedial, when you think, oh yeah, remedial reading or remedial whatever, that sometimes has an academically pejorative connotation. In this case, remedial is not pejorative at all. But what it means is that it is meant to remediate something that the legislature, either on the federal level or the state level, saw as being an issue that needed to be remedied. Again, that could be special education. That could be Section 504 of the Rehabilitation Act, Title IX, Title VI. And that's also true with this. And because it's been enacted in response to what is seen as a need to protect a certain segment of society, or in this case, students, children, these statutes are construed broadly. So it's the exact opposite of criminal statutes. These are construed very broadly. And so if it's ambiguous, if it's I'm not quite sure whether this person would be covered or not covered. And again, unless the statute specifically defines, it's going to be construed in favor of coverage. So I think the definition of these non-employees is sufficiently broad that it would cover people like, again, cafeteria workers, custodial staff. That's if you're contracting out your custodial staff, which does not typically happen, but it can on occasion, I suppose. These people, even though they're not considered perhaps certified professionals, they are nonetheless performing an important function that does bring them into the school under contract and interacting with students. So they would also have this duty, I would say, be found to have this duty also to report. Now,
Mike, sorry to interrupt. We had a question. Would this include bus drivers?
Yes, yeah, I would. That's a great question. And actually, when I have drafted transportation agreements for school districts, I always make sure there's language in there that that advises that bus drivers should, it is presumed as part of the contractual obligation by the bus company, that their drivers will be trained and will understand that they are required to report suspected cases of abuse and negligence. That's a great question. That really is, because I wouldn't have thought of mentioning that, but absolutely. Who has, what non-instructional individual has more day-to-day interaction with students than a bus driver? So in any event, my brother years ago was a bus driver, and he used to tell many tales. Nothing like abuse or anything, but anyway. So yes, that's a great question. So but then there sometimes can be a little bit of tension. Well, geez, we're being contracted with by the district. We saw something. We're not sure if it's not really it's not a student we work with, but we became aware of something. I feel a little uncomfortable because I don't, I'm just in here on a contractual basis, and I really don't, I'm not an employee of the district. So I guess I'll tell you what I'll do. I'll tell a teacher or a building administrator, hey, this happened. And then I'll say, see ya, and then I'll head home. And I'll feel pretty darn good about myself because I have done my bit to help society. Well, that's not sufficient. Doing so would be a violation of the law. They have an independent duty to comply with DCF mandated reporting protocols. Though it's best practice, and in fact, in certain cases, as we'll talk a little bit about later, required to inform school district administrators, that does not discharge them of their own independent obligation. And and that would be true with a bus driver as well. Okay, what triggers the obligation to report? Some people have said to me over the years that, gee, I don't know, this is kind of I'm no expert. This is kind of a gray area. What someone might consider abuse or neglect, I don't see it that way. Or, how am I supposed to know if a kid tells me that he's got a big bruise because he fell off his bike, even though he seems to fall off his bike a lot, because he comes pretty regularly with bruises, how do I know he's not telling me the truth? Don't I have to have trust in this child? Don't I violate my relationship with this child if I am essentially saying, I don't believe you? Well, you know what? You got to use common sense. No one is perfect. No one is right all the time. We're human. And one of the characteristics of being human is that we err, we make mistakes. But you have to, but making a mistake, despite the use of your best efforts and common sense, that's a little bit different than just making a stupid mistake. There are such things as stupid mistakes. I think as teenagers, many of us made them. But so those are the types of mistakes that really are not an excuse. So you have to have reasonable cause to suspect or believe. And that's suspect or believe. So suspicion and belief, they're different gradations. Belief is a little bit more definite than suspicion. Nonetheless, suspicion can be sufficient, a sufficient basis to make a report. Has the child been abused or neglected? And later on, I have a lot of slides, and we'll talk about them a little bit, but I don't think we'll go into them blow by blow as to what indicia, what DCF has seen has listed as indicia of abuse or neglect. Has there been has had a non-accidental physical injury or injury which has had variance with the history given of such injury? Non-accidental physical injury, well, that could probably, if it's a non-accidental physical injury, that's about as clear-cut a case as you're going to get. Yeah, boy, my dad was really angry this morning and he grabbed me by the arm and he really shook me. And yeah, that's why I've got this bruise on my arm. Yeah, he flies off the handle sometimes. Duh, okay. That's a non-accidental physical injury. Or what happened to your arm? Why do you have this sling? Same thing. Well, my dad got pretty angry and he grabbed me and, gave me a yank and my arm popped out, my shoulder popped out. That's a non-accidental physical injury. This other component, an injury which had variance with the history given of such injury, that's, well, again, I'll go back to my example before. A child keeps coming to school with bruises and says, gosh, I fell off my bike again. Or I fell out, he keeps, and you're thinking, well, why would the bruise, if you fell off your bike, why would the bruise be on your inner arm? Why would the bruise be around your neck? Why would there be a bruise around your neck if you fell off a bike? If you had to, why would running into a doorway give you two black eyes? Those are kind of obvious examples, but that's essentially what they mean. That it just doesn't pass the smell test, what the child is telling you. And, I remember a case I had not many years ago, because I did a lot of special ed. which are the students who just want to come to school. Just want to come to school, just want to come to school. I mean, it got to the point where I was sitting at a meeting with the district, and I said at one point, does anyone know if this kid even still exists? Because nobody had actually even seen him or heard from him or anything. And DCF had gone to the house at one point, and the parents wouldn't let them in. And so DCF says, oh, okay, which, a little surprising. But I think one of the reasons that the parents were not compelling the child to come to school is because apparently there was a verbal altercation between the parent and the student, maybe slightly more than verbal. An altercation might be too strong of a word, but a disagreement, let's say a debate, a dispute as to whether the child should get on the school bus and go to school or not. And the kid called DCF on his own parent. And they had no finding. I mean, there was nothing there. And that is no, I'm not faulting DCF when I say that. I mean, it's my understanding of what occurred. There was no basis for it. And so the kid then used that as a leverage over the parent that, hey, you make me do that again, I'm going to call DCF on you again. And the father basically said, I'm not going through that again. But those are kind of hopefully rare cases. Typically, it would be the other end of the spectrum where you might have a child who'd say, I really don't want to get my dad in trouble. I don't want to get my mom in trouble. What will happen to me? What will happen to me if something happens to them? Maybe the parent even says to them, if you tell anybody, about this, I'm going to go to prison and you're going to be out on the street. So you never know what's going on. So they might come up with these stories about falling off a bike or tripping or running into a doorway. So you really got to use your common sense.
Mike, there was a question about what constitutes a physical injury. So, I mean, you gave some pretty obvious examples, a black eye, bruises. Right. What about scratches or redness, that type of thing? I mean, how much speculation on the observer's part is required, I guess, as part of that?
Yeah, that's really a good question as well. It's a difficult, and this is not just some lawyer ploy to get away from answering it. It's a difficult question because each of these cases really have to be considered in and of themselves. And I think there has to be a certain amount of context. Is this really unusual? Yeah, the child's been coming to school every day for a couple of years, no issues, and then he comes in one day and he's got some scratches, or he's got some red marks, and he says, "Oh yeah, I got my arm caught in something, and I kind of left this red mark, or yeah, I scratched it in some thorn bushes, that sort of thing." Well, again, you're trying to use common sense. You're not expected to be right every time. But again, you got to use common sense. Now, if it's a kid who comes with scratches a lot, oh, well, our cat keeps scratching me. Maybe, and maybe there are other indicia. Maybe the kid is not doing as well in school. Maybe his grades or her grades are slipping. Maybe they're having behavioral issues that perhaps they didn't have before. So you look at these constellation of circumstances and you think there's enough there, I think, where I've got to err on the side of reporting.
Now, if a student says, there's no mark of an injury, but a student says, my parent, slapped me this morning, so you may not see anything, but if they give you something verbal like that, you don't need to corroborate that with evidence of an injury.
No, it's like that, example I gave about the young lad who didn't want to get on the school bus, and he called DCF, and DCF investigated. So no, if a student tells you something like that, yeah, absolutely, that's the sort of thing you really need to follow up on. And you're acting in good faith. It's not like you're saying, yeah, this parent's a real pain in the neck. Geez, I'm tired of him complaining or always contacting me. Yeah, the kid said he slapped him. So, I mean, the child tells you that. You cannot just simply say, oh, Jimmy. Now, I'm saying that, but at the same time, I'm thinking of the obvious question coming up from that is that, well, what if this student is known to exaggerate? What if the student makes things up a lot? What if the student claims that the kid like took something of his and they never did, or that the teacher said something that she never said? Um, isn't that part of those constellation of circumstances you're talking about? Isn't that something, one of those, that contextual type stuff you said we need to keep in mind? It is, but at the same time, that would be such a really kind of a troubling and almost shocking thing for a child to go and say, "Oh, my parent really slapped me hard today." Thinking, Johnny said a lot of the type of stuff before, so I'm just going to say, okay, Johnny, go ahead, continue with your work, go on to class, and ignore it. You were taking a big risk. It's as simple as that. I mean, as people have heard me talk before, saying, "Oh my God, he's going to say this again," but I'll say it again. As educators, I always see educators as having two obligations. The first primary one, of course, is to educate. That's why you do it. That's why you got into this area, because you enjoy working with kids and guiding them and educating them, opening their eyes up to all the knowledge that's out there. So that your number one obligation is to educate. But your second obligation, and it's the one you owe to yourself as well as to your employing school district or school, is to practice defensive education. That's what I call it. It's like, defensive driving, defensive education. So then you got a situation where a student comes up and says, "Yeah, my dad really slapped me this morning." And you're thinking, this kid, you're thinking this, of course, not saying it. This kid lies like a rug. And yet, so I don't know really to believe this. But if I just shrug it off and it turns out it's true, I could find myself out of a job. I could find myself being disciplined, or maybe even including out of a job. I could find myself under criminal investigation. I mean, obviously, those are the most serious extremes, but it can happen. So I think that situation, you owe it to the child, just in case the child's telling you for once in his or her life, they're telling you the truth. You owe it to the child, and you owe it to yourself and to your employer to say, "You know what, I'm going to make a call." If it turns out that the kid was making it up, well, okay, you did your duty. And it actually might be one of the most educational experiences this child has ever had, because they've suddenly, put their parents in a very precarious situation. So I think all the way around, it's the right thing to do.
So we've gotten a couple questions kind of
Sure.
on the same line about, parental discipline versus abuse in terms of what parents can and can't do, and what the role of the teacher or the reporter is in terms of making that differentiation. And then again, kind of in the same line, what if the student says, "Oh yeah, my dad used to slap me, but it hasn't happened in a year, or it hasn't happened over a period of time. So it's not an immediate report, but something that had happened in the past." So we've gotten several questions about parental discipline, and then also kind of a time frame of, is there a statute of limitations, so to speak, in terms of when the action may have occurred?
That's a good question, and I'm going to come back to it in a little few minutes, but just because it kind of it ties in a little bit to something I'm going to be talking about. So I'm not trying to dodge it. I just think it'll tie in a little bit better later. As far as the discipline goes, yeah, that really, oh my God. I grew up in the "I'll give you something to be unhappy about" era. And I had a very non-abusive, very loving parents. But nonetheless, discipline today is not, the societal norms for discipline today are not the same as they were some years ago. Not that it was that long ago when I was a kid, but I think you know what I mean. And again, one man's reasonable discipline is another man's over-the-top discipline. Corporal punishment is not in the home, is not per se illegal, but this again, and I wish I could give you what they call in the law a bright line rule, that if this happens, boom, absolutely. If that doesn't happen, you're good. But it really is kind of a case-by-case situation. If you remember Adrian Peterson, the great NFL running back, who was suspended from the NFL a few years ago because he, for some perplexing reason, decided to share with the world that he used a switch to beat his young child with as a form of discipline. Something like that's obviously over the top. I mean, I think if there's actual marks from the discipline, well, I think that's an easier call. If there are if the father or mother's idea of discipline is a slap in the face, I think that's a pretty easy call. The traditional, bend over and they take out a paddle and the kid gets paddled, that's really a closer call. I mean, I guess it comes down to, oh yeah, my dad, he really gave me a whack, yesterday because I had, I did such and such. He got really angry at me. I mean, I guess you can try to tease out a little bit more. Well, what do you mean? Oh yeah, he took the paddle and he gave me a whack, on the backside. If he did it once, he did it through clothes, he did it even a couple of times through clothes, well, maybe that's not the sort of discipline you would subscribe to, the disciplinary theory that you would follow. But at that far, so out of bounds that would constitute abuse, I don't know. But the kid says, oh, I had to pull down my pants and he hit me 10 times or something like that. Yeah, I think that now is getting to the point where it's better to err on the side of making a report than not. Again,
So here-
I'm just throwing those numbers out. I'm not saying
Yeah.
they'll say, oh yeah, well, the kid said his father hit him 9 times, but that attorney told us it was 10 times. That's what we call it. That's not what I'm saying. Yeah, Bill.
So a couple kind of related questions, I guess more about reporting itself. So here's a question. What if a parent calls the school and reports that their son or daughter told them a concern about a friend that could warrant a DCF report? So who's required to make the report? Should the school tell the parent, make the report, or is it now that the school knows about them, must the school report?
Remember the old saying, ignorance is bliss? There's a reason for that. Yeah, the parent's on a mandated, the parent would have no obligation. If the school, if they're advised of the school, it's up to the school to follow up on that and make the report. And and I'm going to talk a little bit about in a few minutes, is that this is not beyond a reasonable doubt. This is not even more likely than not. You are not a prosecutor. You are not a police detective. You do not establish that, yep, it happened. Again, it just has to be a suspicion or a belief, a reasonable belief that abuse had occurred. So you have a child who told a parent, what we call, and they tell you, it's what we call double hearsay. Nonetheless, you have been alerted that this is going on. That's like if someone came up to you, a student came up to you as a teacher or a paraprofessional or an administrator or what have you, and said, a friend of mine, she is having a sexual relationship with another teacher. Well, you're being told by a third party, and you would obviously want to follow up on that, as promptly as possible. You're being told by a third party here as well. And I think that it's refreshing in a certain way that the child has that good of a relationship with his or her own parent to tell them that the parent is responsible enough to let you know, instead of saying, not my problem. I'm not getting in the middle of this. So I would say that once this has come to your attention, if the student is, within your school, what have you, then you do have an obligation. Now, if they tell you, I think if they tell you about some random kid somewhere that it's not, you don't know who the kid is, or not within your school or something like that, well, that might be a different story. Because you don't know who this person is, you don't know any of the circumstances. But in any event, I think in this case that the situation you just mentioned, I think that you would have an obligation to report. And back to the discipline, I think that, again, it really, I mean, I don't want you to leave this presentation day thinking, hey, man, I am dropping a dime left and right because this guy's telling me I better call rather than not call. And yeah, I'm saying if it's a judgment call and it could go either way, well, I would err on the side of calling the DCF care line. But again, use those two words, common sense. You really got to really kind of consider what you're being told. There is such a thing as corporal punishment, but there's such a thing as excessive corporal punishment as well. And there's also emotional abuse. It's not just physical abuse. Oh God, my mother yesterday, she gets so angry at me. She called me this, that, and the other thing. She said that I was a loser, that I was never going to amount to anything, that I was worthless. She wishes she had never had me. She wishes that she could just get away from me. That I'm the worst mistake she ever made. Well, that's not involving a paddle or anything like that, but it's it's pretty emotionally abusive, and so that could also trigger an obligation. Again, we're human beings. We get angry. We say things, and then later we say, "Sorry, I shouldn't have said that." Between men and women, it helps keep the floral industry in business. We all say things, intemperate things, at different times. But when you get a situation where you've got an adult who's saying these very, very toxic, abusive things to the child, and hey, believe me, I know kids can really push. Having had a child of my own, children can sometimes push parents to the brink. But we are adults. We're supposed to be able to, hold it together. So there can be situations in which it may not be a physical abuse, but it can be emotional abuse. And again, I'm going to talk a little bit more about that down the road. Okay, finally, there's an obligation to report if you think a child is placed at imminent risk of serious harm. A parent is, that's a little bit sketchier to come up with a good analogy for that. You guys probably could do so better than I can because you actually interact with kids on a daily basis. But maybe the parents have a very young child, and you find out that they're going out of town for a week and leaving the kid to fend for himself. Maybe they're making the child walk beyond the bus transportation. They live outside the scope of in which they'd be expected to walk to school, and it's through a really dangerous area. They're just a couple of examples I'm coming up with, but if you hear that, wow, this doesn't sound like this kid is in a good way. She's going home. Oh yeah, my mom's got a new boyfriend. He just got out of prison or something. Or you find out that he's on the sexual predators list, and this girl's going home unattended to this house, something like that. That's an imminent risk of serious harm. Maybe the guy's seen the error of his ways and reformed, but really, do you want to take that chance? So you must report or cause a report to be made to DCF. I don't like that cause a report. I don't like that language. I didn't come up with it, but it's statute because it almost seems to contradict the imperative that you each have an independent obligation to report. You can't just foist it off on someone else, but you must report this. All right. Well, this statutory definition of abuse sort of echoes what we were talking about a little bit before. Physical injury other than by accidental means. The story the kid is giving you is different than what seems to be the case. Child's coming to school malnutritioned, or you find out, God forbid, sexual molestation or exploitation, and he or she's being deprived of necessities. They're coming to school and they're not they have horrible personal hygiene. They're wearing, the same matted clothing and so forth. Now you gotta be careful, as we're gonna talk a little bit about before, the next slide. This is not the result of impoverishment. And that the clothes are still warm and, the parents are doing the best thing they can. We're talking about these situations where I had a case once some years ago where a student was coming to a middle school and he was basically starving. I mean, he would just be wolfing down food. He was getting no food at home, or very little food. And it wasn't really a case of lack of economic ability. It was just the parents are just totally negligent. I mean, it really rose to the level of almost abuse. So there's another situation. I mean, sexual molestation, again, that's pretty obvious. Okay. Neglect, again, for other reasons other than being impoverished, he has been abandoned, is being denied proper care and attention, is being permitted to live under injurious conditions, circumstances. Now, this is sort of a tricky statute. This is kind of some interesting language. Other than being impoverished. Well, that's something confusing. It's almost like just saying, yeah, well, that's a poor kid. What the hell? Don't worry about him or her. It's a poor kid. Now this classmate from the who lives on the big house on the hill, well, no, that's a different situation. Obviously, that's not the legislature's intent. They don't mean to say that kids of more or of greater affluence have more protections than those who do not. Furthermore, I mean, it's equally applicable to an impoverished child who's abandoned, denied proper care, or again, forced to live in an environment that could be injurious to the child's well-being. Essentially what the purpose of this reference is so you don't confuse poverty with neglect. So in other words, a kid's coming to school, the clothes are clean, but they're ragged, they're threadbare, but the child is warm, the clothes are clean. Child maybe has terrible teeth, maybe they could be better, but he's clean, he seems to be well maintained. And some of these circumstances that he or she's exhibiting is simply the result of the family being in a very tough economic situation. So the parents aren't being neglectful. They're loving, they're nurturing their child, but they just don't have that much. So that's essentially that's essentially what the legislature was trying to kind of tease out. I think that's a laudable motivation, but I think it can make things a little bit more confusing and unclear for schools because, I mean, I think most schools are going to have a fairly good sense as to where the child's coming from as far as economic situation and so forth. Maybe not, but I think in a lot of cases they will. So you really kind of have to look at the whole child and try to again tease out what's the catalyst for this. It makes your life a little bit more difficult, but your teacher's in the state of Connecticut, so that kind of is part of your job description, I guess. Okay.
Before you
Sure.
go on, Mike,
Sure.
there was a question, your position on reporting to DCF for a child who, has chronic attendance issues on the grounds of educational neglect.
I'm a big believer in that. I really am. One of the most intractable problems for, at least I see it more in the context of special education, because like I said, I do a lot of special ed, is school avoidance. I've spoken on it, both, statewide and nationally. And so you would think that I'd have like the end all, have the inner wisdom that would just solve the problem. I don't. Not many people do. But I think that ultimately it's a tool. Now, the DCF, they, as my longtime administrative assistant who recently retired used to say, it makes me mental. And DCF sometimes makes me mental. Because some of these cases, you get them involved, they don't seem to do as much as you would like them to do. Other times they come through like champs, but sometimes it's very frustrating. But, family with service needs, you can't make those referrals anymore for attendance, truancy, so forth. But you can file for education neglect. And I think that's important for a number of reasons. One, it's for the benefit of the child. Number two, it's the hope that if DCF gets involved, that might be the little oomph that the parents need to get the child back into school. Three, if you don't do anything, this child is not going to be getting an education. And if there's special education in particular, at some point down the road, someone's going to be making a claim against you for compensatory education. And what you will be asked by a parent attorney who knows their stuff will be, okay, well, tell me about your truancy referral. Yeah, maybe we didn't make one. Well, tell me about, did you file as DCF? No, we didn't. So you're thinking, gee, we didn't really want to get sick DCF on these people. We thought we were being nice guys. No good deed goes unpunished, unfortunately, when it comes to those situations. So you really, again, number one, you're protecting the child. And ultimately, you're protecting yourself. So that gets back into my education and defensive education. So yes, absolutely. I really think you need to file educational neglect provisions because I'm fortunate. I had a child who liked to go to school, and I know that sometimes parents have their hands full. I told you about the anecdote about the father who said, forget it. I don't want another my kid to call DCF on me again. But, if parents are going to abdicate their responsibilities and not make sure the kid gets out of school, out of the home into school, well, they have to be assisted. And this assistance might come in the way, and they might not see it as assistance, but the assistance might come in the way of a DCF referral.
And would you say the same thing for a student who's not showing up remotely?
Oh, I'm going to talk a little bit about that. And yeah, it's funny. Well, maybe not funny, but I'm going to talk a little bit about that in a little while. And the State Department of Education has kind of tied itself into a knot, basically saying, well, with a remote instruction, it's traumatic. The pandemic's traumatic for all of us. And so they really, and I'll go over that in a little bit, the steps that they think you should take before you make the educational neglect referral. I think it's a little over the top. I think that the bottom line is you need to get the child to attend his or her education. But definitely those, coming to school. Now, you could, with parents, the traditional excuse by parents was that, oh, my child's not coming to school because he was being bullied. He never reported any bullying. There was never any witnessing of bullying. There was never any indication of bullying, but now it becomes a convenient excuse. Now it might be, well, there's the pandemic. My child is afraid he's going to get COVID. I'm afraid he's going to get COVID, so I'm not going to have him go to school. But, there's a statutory duty to ensure that your children go to school. And if they're not complying with it, yeah, absolutely. Education neglect is the way to go. You might be frustrated. It might not result in anything, but you know that you will have done what you can, everything you can do. Okay. Yes.
Can I backtrack for just a second
Sure.
About reporting? And here, an example where a student tells a teacher, let's say, or an administrator about a student in another school. Is there an obligation to press for details so you're able to inform the other school about this situation?
Now, when you say another school, do you mean a school within your own district or?
Well,
like
let's say not, let's say, a school in a neighboring town or something.
Boy, that's a tough question. You know, my immediate response is to say, what does it hurt for you to pick up the phone and call your counterpart at this other school and say, hey, we have a child here who said, do you have a Janie Smith in your school? Because we have a student here who's claiming that Jamie Smith has been, sexually abused or physically abused or is being, neglected. We don't know her. We have no way of investigating her situation. And as you'll see when you get into this, when you make a report, there's certain information you have to provide. Well, you would not have that information. But I think that, so I guess technically you wouldn't be obligated to report this, but I think best practice is that you do. That again, you call your counterpart and say, we just want to relay this on to you. And now you've taken the ball and you're saying, yeah, but Mike, you said before that everybody has an independent duty to report. And now you're telling us you've given the ball over to this other person. Well, again, it's a different situation. You don't know this other student. You know nothing about them. You don't know their name. You don't know where they live. You don't know what's going on. So you call but you're concerned from what you're hearing. So I think you contact your counterpart in the other school. And you know what, I would do it. I would, call is probably the quickest, but I think I would follow up maybe even in writing, just so you have a record that you did what you did. But at the very least, I think you should call. Now, if it's a school within your own district, yeah, absolutely, you need to essentially do the same thing, but it's even more of an imperative there because now we're looking at part of the same employer. So yes, okay, suspicion or belief, we're back to that, based on factors including but not limited to observations, allegations, facts or statements by a child, victim, or third party. Does not require certainty or even probable cause. Mighta, coulda, in other words, might have happened, could have happened, seems credible. That's basically all you need. Again, remedial statute, we're interpreting this broadly on behalf of students. You do not need to confirm that it took place. You just need a reasonable suspicion. You do not conduct your own investigation before making a report. Now, after the fact, after you've made the report, yeah, you can conduct your own investigation, but not before you make a report. You're not Columbo, you're not Sherlock Holmes, you're not an investigator. Let the people who are trained to do the investigations do the investigations. And it is your individual obligation to make a report. Okay, let me give you an example. Torn from reality. This situation, a security guard at a high school reports to an assistant principal that a student claimed that she was having sexual relations with a teacher. Now, that's obviously a fairly alarming report. Assistant principal tells him, don't worry about it, I'll handle it. So he doesn't make a report. So rather than call DCF, despite, and let me underscore the fact that the teacher in question and the student in question were no. I mean, it's not like, well, they talk about some teacher somewhere in the school. No. This teacher was named. So rather than call DCF, the assistant principal reports what she was told to the principal. Principal says, I'll handle it. So the assistant principal doesn't call DCF either. Principal then decides, wow, this is pretty explosive stuff. I mean, this is the sort of allegation that could destroy someone's career. And frankly, that could reflect poorly on me and my supervisory authority over the school. So I'm going to conduct an investigation. So she enlists a custodian as her chief investigator and conducts surveillance and explain to him what's going on. So I want you to keep an eye on this teacher and also this student. And weeks pass. Well, yeah, they were talking in the parking lot. but nothing dispositive is determined. So weeks are going by since they first learned that there was a sexual relationship allegedly going on. As it turned out, it was going on. And the student finally tells her outside therapist about the relationship. Therapist, as the therapist is required to do by statute, promptly alerts DCF. So gets back to the school district. The principal and assistant principal are arrested. They plead guilty. Their employment is terminated, and the security guard and custodian are suspended. None of them they all had an independent duty called DCF, none of them did it. They all felt that the allegation wasn't enough. We need to nail this down and prove it. They didn't need to do that. We need to conduct our own investigation before we report it. They didn't need to do that. So it's reasonable suspicion or belief is sufficient. Now, the timelines. The statute doesn't give you much much in the way of time. They talk about immediately reporting it. In no case later than 12 hours after having such a suspicion or belief. So if you find out about it, it doesn't mean that you immediately have to drop everything you're doing and call DCF, although the sooner the better. But at the very least, you have to do it within 12 hours of having forming the suspicion or belief. And here's the DCF Caroline. And here again is another example, which actually happened. Middle school, having an extracurricular group meeting late on a Thursday afternoon. A teacher overhears a student, and it's an extracurricular group that is geared towards students who are, they're recognizing, coming to grips, struggling, whatever word you want to use. Different students are at different stages with their sexual orientation, sexual identity. So it's great. I mean, it's great that they have this extracurricular group. But the teacher who dreamed it up and who's overseeing it, she overhears a student telling another student that he had been sexually assaulted at a sleepover the prior weekend. He'd been sexually assaulted by one of his classmates who was having that sleepover. So uncertain as to whether this is credible and whether she has to, it happened off school ground on the weekend. I don't know really, do I have to report that even if it happened? I'm not sure. So I'm going to go talk to the guidance counselor. So the next morning, still within the 12 hours, well, no, actually it wasn't within 12 hours, but so she's already violated the law. So she speaks with the guidance counselor on Friday morning. Guidance counselor says, that's a close call. I'm going to think about it over the weekend. The weekend comes, no report's been made. Both the teacher and guidance counselor have now violated Connecticut law and are subject to school discipline and criminal prosecution. As it turns out, once someone else became aware of this, they immediately reported it from the school, reported it to DCF. DCF conducted an investigation. And it turned out to be a credible allegation, unfortunately. Now, someone was asking me about time frame. I did not forget that question. I wasn't just putting you off. DCF had the electronic reporting option. Typically you drop the dime, you pick up the phone, you call, but they also have an electronic reporting option. So instead of telephoning, you can use this electronic reporting process, but only for what they call non-emergent suspicions of abuse or neglect. Now, a non-emergent suspicion is when the student is not in immediate harm, does not currently have a need for urgent or emergent medical or mental health care, and there's no risk that he or she, is going to be subject to further abuse or neglect within the next 24 hours, or it's going to disappear. It's going to be inaccessible and you're not going to be able to track him or her down. So the example I just gave about the middle school student who had been sexually assaulted at the sleepover the prior weekend, as terrible a situation that child endured, this would be a non-emergent type situation because he's leaving school where he's safe, he's going home where he's safe. So instead of calling, you could use this electronic reporting option. So, and here are some of the criteria to consider as to whether it's emergent or non-emergent. In other words, should I use the phone or should I use the electronic system? If this were a different situation, the child had said he had been sexually abused by a parent or by a sibling or someone at home, and they were showing a fear of returning to their home, yeah, that's not emergent anymore. That's emergent. That's a phone. You need to make a phone call. Is there a recent injury, recent incident of abuse or neglect? In other words, this is like an immediate. This has been just happened, abuse or neglect. Possibility of it continuing. It requires a immediate response. And if there's a child of developmental age, it requires supervision. It's not going to be without a responsive caregiver. Those are situations where you need to make the call instead of the electronic submission. So I come back to the question of what if someone tells you like a year ago or 2 years ago their father had slapped them. That much time, yeah. That's if 2 years has passed and they only slapped them once, that's a real tough one. I mean, it was kind of a systemic kind of thing where the parent had a tendency to do that on more than one occasion. I think it makes it a little bit clearer. If it was just this isolated incident and it was like 2 years have passed and the father or the parent, the mother, whatever, has been, nurturing and so forth. I think that I guess you could err on the side of, I guess ultimately you could call the care line and say, this is what I'm looking at here. And explain the situation. And DCF may say, well, that doesn't sound like something that we need to investigate. You've done your duty. It's off your conscience. It's off your hands. The statute of limitations, I'm not really aware of statute of limitations in this situation like that, particularly for sexual abuse. So I do think that if a student talked about severe abuse that they had experienced a couple of years before, yeah, I think you would call. And I guess the rationale, to a certain extent, obviously the legal obligations, but also on a more practical, pragmatic level, why put yourself in the position of trying to sort through this and figure it out? Call DCF. That's what they get paid to do. That's their job, to figure it out. So you contact them, you tell them, this is what we've heard. The child said he was beaten up pretty badly by the parent 2 years ago. Seemed to have had no problems since then. So we just felt that we should err on the side of caution and call you. And then DCF may say, like I said, hey, great, thanks. We'll look into it. Or they might say, now, okay, time's gone by. We'll we don't know if this is worth opening a case. Well, I shouldn't say worth, but this is the case that warrants opening up a matter, an investigation. It's DCF's decision, not yours. So there's a slide that's, Bill, were you gonna say something?
So two kind of related follow-ups. What if in that situation, the student tells you that DCF had been called on the prior occasion?
Oh, really? So DCF had already been involved and investigated it?
You're right.
Well, I don't think then you would need to call. I mean, if DCF is still involved, if it happens again, well, then you call, or even if they weren't involved, you'd call DCF again. But I think if the DCF had gotten involved and there hadn't been anything since then, I don't think you'd have an obligation to call. Wow, that's a real interesting pattern there. So these slides just kind of, and I think you're going to get a copy of them and so forth. So these slides just basically tell you, when you can make the electronic reports and how you do it.
A clarification on that. Someone asked, with the risk of a student not being accessible within the next 24 hours on a Friday, let's say, you should you always call on a Friday rather than do the submission, since the student won't be accessible to you or to the school over the weekend?
Yeah, I think that's a good point. And you know what, I was just, another slide or two, I was just gonna talk about that, just, let me just say though, before I get to that, is that if circumstances change and what seemed to be a non-emergent situation has suddenly become emergent, well, you need to call. Even if, you need to call. It's like suddenly, it's like a new referral. It's like special education. This is a new referral. Um, the, situation shifts and suddenly the kid is ready to go home or they're in imminent harm. Hey, when we first heard this, we didn't think it was something that was an immediate threat to the child, but now we do. Then you need to call. And this is just following up on what Bill was just asking or conveying, the question he was just conveying. So I'm thinking of this, telephonic versus electronic. I think, well, an advantage is that you do receive a written confirmation if you do it electronically that the report has been submitted. Well, that's nice. I like, as a lawyer, I like things in writing. I like to see documents. But the disadvantage, okay, sort of like what I said before, now suddenly you've got to figure out, was this an emergent or a non-emergent situation? Why are you taking that upon yourself? Why are you taking on this additional obligation to determine whether this is emergent or non-emergent? If you just make a telephonic report in all situations, it eliminates the guesswork and the possibility that, hey, I'm doing the right thing. Well, no, actually, you're doing the wrong thing. I mean, that's always the biggest bummer if you're thinking, wow, I did a nice thing there, and it turned out, well, no, you really didn't. This is a terrible analogy. I know, and it'll reveal a glimpse into my own tortured psyche. But when you're in a car and someone ahead and there's a green light, you're trying to get somewhere, you're running a little late, and the person in front of you suddenly stops and lets people start coming in from side roads. I'm doing a nice thing. I'm just in the back thinking, I know you're up there thinking, I'm doing a nice thing, but actually you're sticking it to me. Obviously, that's a terrible analogy, but nonetheless, the fact is, in a situation like this, why not just call? It eliminates all doubt. It eliminates all ambiguity. You're not having to get into this whole tangle of this emergent or non-emergent. Some people don't like to talk on the phone, or they think it's just going to be a little bit more anonymous by doing it electronically. Obviously, you've got to do what you're the most comfortable with, so long as it's in compliance with the law and the legal requirements. But I just think that calling all the time just keeps it easy. Okay, once you've made the call or filed the electronic report, if you choose to ignore me and still do the electronic report, you have to submit a written report to DCF within 48 hours of making the oral report. There's forms, fillable forms, and you have to provide a copy of the written report to your building principal, and if like a public school district, the superintendent of schools. I guess if you're a part of an archdiocesan school system, the archdioceses also typically have a superintendent to provide that individual with a copy as well. Now, the exception to this is if the principal or the superintendent is the one who is being accused of the abuse. Well, you don't have to provide them with the written copy of the written report. You would circumvent them and give it to someone else, whoever's next, over the principal or the superintendent, whoever's above the superintendent or below the superintendent. I guess like an assistant superintendent, but you would not be required to give it to the actual perpetrator. If the alleged perpetrator is a school employee, the superintendent must notify the child's parents and guardians that a report was made. Okay, so it's funny. I didn't know if I'd have enough time to cover everything, and now I don't know if I'm. No, I thought I'd have more time than I needed. Now I don't know if I'm going to have enough time. So you're going to get a copy of these slides, so you can see all the information you need to fill out here. That's why what I was referring to when I said before that if you're calling another school district or another private school because you've gotten a report about a kid in that school, you're not going to be able to fill out this stuff because you don't know any of this stuff. That's why you would contact the person in the other district, the other school. All this information. I am, however, going to highlight a couple of things. One thing, you have to find information concerning any previous injuries to maltreatment of or neglect to the child or his or her siblings, and any information concerning any prior cases in which such person or persons have been suspected of causing an injury. That's pretty interesting stuff. These are obligatory entries, and as a reporter, you will have an obligation to submit accurate, true, and complete reports. So, as a lawyer, I'm thinking, well, so if you're putting in and say, oh yeah, this child's had a string of other injuries, are you making what's known as an admission against interest? You're basically admitting to something that goes against your interest. What? They had string of previous injuries, you never reported it? What the hell? So obviously you need to be accurate, true, and complete when you submit these reports. But knowing that you're going to have to give this information, it's sort of like kind of retrofitting your perspective of what's going on. It's important to consider this, so when it's instructive, I think, to consider not only in and of the act in and of itself, but how's this going to look in retrospect? The kid has come a couple of times and he's had some bruises. I didn't really give it much thought, but now it's just starting to form a pattern. If I let this slide by, am I going to then have to say, well, he had a bruise on this day, he had a bruise on that day, he had a bruise on the next day? So it really kind of, I think, heightens the awareness that you need. If you have the reasonable suspicion or belief, you should make the call. Confidentiality, typically, if you request confidentiality, you'll be given it unless the need to communicate with the law enforcement, prosecutors, courts, district administration. Typically it's going to come. I think for the most part it's going to come out. But you're doing the right thing and you're required to do it. So it does. I mean, obviously, it does not engender warm and fuzzy feelings from the parent, but you're doing what you're required to do by law, and you're doing what's in the best interest of the child. It's like, sometimes if I'm in a trial or something and someone doesn't want to testify because the other party is like a coworker or something, I'll always make sure to ask them, you were subpoenaed to be here. In other words, you were compelled to be here. Isn't that true? And I do that just to try to give them a little bit of cover. I mean, I will issue a subpoena so that I'm not getting them to perjure themselves. This is the same sort of thing. It's not like you have any discretion here. If you have this reasonable suspicion and belief, you have a mandated duty to report. So, you're simply doing your job. Okay. The DCF, you have to cooperate. Duty to cooperate trumps any privacy protection, that includes FERPA, the Family Educational Rights and Privacy Act, which the federal law that protects student confidentiality. DCF has had any records about a teacher or other staff member, who might have been involved in the suspected abuse or neglect. The school must give priority to investigation conducted by DCF or the appropriate police agency. Although I think the school should conduct its own investigation, having once DCF or law enforcement tells you, hey, if you want to conduct an investigation, it's not going to interfere with our investigation, then I think it's appropriate for you to conduct your own investigation. And I'm saying that in the situation in which a teacher or other employee of the school district is the one who's been accused of this misconduct. I think you really need to be on top of that because this is your employee. This is your contract. It's someone you're contracting with or someone you're employing. So it is important that you conduct your own interview. The kid, you should try to minimize the number of interviews for the child. DCF and police get first crack. Maybe they'll share with you what the child said to them in their interviews. If not, you have to interview the child yourself. But again, you should. The child should not be victimized again, obviously. by having to go through endless interviews and having to relive this over and over again.
Mike,
You know-
can I ask about the
Sure.
anonymous reports?
Sure.
Does DCF, if a parent asks, does DCF have to tell them? And do parents see the report that have the signatures on them if the person is asked to remain anonymous?
DCF does not have to share that with a parent. And essentially what they will see is the DCF report. I don't believe they are entitled to the actual mandated reporting report. They're just basically the report that DCF has created. Now, it might reference, you might say, listen, I want my anonymity. And I think for the most part, DCF might will cooperate with you and try to mask the individual's identity. But sometimes they won't, especially if it's serious enough that it's going to involve criminal investigation and that sort of thing. So your anonymity, because obviously it wants to foster this sense of reporting and encourage reporting, so they're going to do what it can. But there are situations where confidentiality is just simply not possible. You have to include an opportunity for the suspected perpetrator to be heard. Again, we're talking if this is an employee of yours. When you're why would the school conduct an investigation, quite frankly, unless it was someone, the abuse or neglect was caused by one of their own personnel. DCF wants to interview a student, or if you want to interview a student, you really should let the parent know, unless the parent, of course, is the alleged perpetrator. But ultimately, DCF calls the shots on that. You just have to consent and work with DCF. Not consent, excuse me. You have to cooperate and work with DCF. The fact that DCF might conduct an investigation and find no cause, that does not mean that you cannot discipline an employee, that you cannot investigate and discipline an employee. I have been involved in cases which I get involved when the disciplined employee sued the school district and went to federal court, and we prevailed both in court and then on the appeal. But the DCF investigation ultimately found that this teacher, he was like a math teacher, and he was really making these inappropriate comments to students, asking them, in the middle school, and these, very inappropriate questions, insinuating sexual activity, and drawing what were supposed to be geometric figures that are very phallic in nature, and weird, creepy stuff like this. He was not fired. But he was suspended, and then he sued the school district. And the thing is, even though DCF said, well, yeah, the guy's a creeper, but it's not sufficient to, find, to corroborate, substantiate this claim. There was enough in the report that we thought, hey, this is totally inappropriate conduct. And maybe not to the level of termination, because he had a fairly spotless record before that, but it's enough where he should at least be suspended. So you can still take disciplinary action. You are not bound by DCF's finding of no substantiation. Now, of course, if they substantiate it, you absolutely should be moving to terminate the teacher. I've been involved a few of those termination. I've prosecuted a few of those termination hearings. Kid like that, you don't take disciplinary action against a teacher or a staff member who's involved in that kind of misconduct. You are opening yourself up to all sorts of liability when they do it again. I said before,
this may be a related
Okay.
question to what you were just talking about. It says, what about an issue which may concern both Title IX and DCF? Which investigation takes priority? What other considerations would there need to be with an employee working for the district versus someone outside of the district?
well, if it's an employee, you need to follow the same disciplinary procedures you would for any other allegation. They have the opportunity to be heard. They can be put on paid administrative leave. pending an investigation. And if the investigation substantiates, a basis for these claims and it's serious misconduct, suspend or seek to terminate. It's easy for me to say that because the termination process, at least among tenured public school teachers, is can be time consuming and expensive, but nonetheless, it's the right thing to do if the person is engaged in totally inappropriate behavior. Title IX investigation, that's a good question because it has to do with sexual harassment. These two things can overlap. Again, I'd say the DCF or / law enforcement investigation has to take precedence, and you can then conduct your investigation as well. You might be able to do it on a parallel track. In other words, I don't know if you necessarily need. DCF typically takes about 45 days to get out its reports. I'm not saying you necessarily need to sit on your hands for 45 days, but you really need to first touch base with DCF or the police, again, whoever's conducting the investigation, and say, listen, we got this Title IX concern. We have an obligation to investigate under this. Though under the new regulations, that investigation is only triggered by the victim or someone making a written complaint seeking an investigation. But that's a side note. So you could conduct a parallel, or if necessary, DCF says, no, we don't want you in mucking around with our investigation. I think the police might do that more than DCF. You might have to hold off. But again, when it's one of your own employees, you really need to, DCF might start out by doing the heavy lifting, but then you also really are, you really have a need and a necessity to conduct your own investigation as well. Because good God, if you get some kind of abusive individual in your school, you don't want that person there. You want to protect the children, and also you want to protect yourself, once again, from future liability. All right. A lot of these slides, I know I'm running out of time, I'm sorry. I was a little more verbose, I guess, than I anticipated. But essentially what this is saying is that, when kids are learning from a virtual perspective, this has been a traumatic situation for all of us. And there might be situations where a child is not attending virtual instruction because maybe they don't have wireless, maybe they don't have laptops. That's rarer and rarer in Connecticut, I think. But maybe more so, they don't have the technological capabilities to access virtual instruction. That is not neglect. That's sort of almost like if the suspected negligence is the result solely of the person's impoverishment. It's not really neglect, it's just the person is poor. This is kind of a parallel to that. So what the State Department has really, the State Department of Education has tried to emphasize that you really need to take it a little bit slower. Now you kind of got DCF that says you got to, as soon as you suspect it within 12 hours, you've got to report it. And then the State Department saying, well, maybe you need to make sure that this hasn't got something else going on there, a lack of technological, that sort of thing. So I think you reconcile the two, what appear to be competing principles here by saying that, well, my reasonable suspicion. So State Department saying before you form a reasonable suspicion, you might want to consider this, that, and the other thing. Is something else going on that is precluding the child from accessing his or her education? It's not neglect at all. It's loving parents are doing their best, but the kid just can't access remote instruction. Now, and they suggest things like meetings, trying to have meetings with parents, trying to speak with the parents, consider interventions that might help. The State Department has made clear you're not required to have people go to the house, but maybe you try some interventions to see what's going on with the family and see if you can rectify it. But if the parents are just not really responsive and they're kind of blowing it off, now we're talking about a different kettle of fish. I remember not talking about it, but that is a different kettle of fish, and that's educational neglect. So essentially, there's a lot of slides here that talk about it, and there seems to be this kind of almost overkill from the State Department of Education. But the bottom line is that they're saying, hey, we're not in normal times. Things might be, kids might not be accessing their education for reasons totally non-related to neglect or abuse. The other aspect of this is that, when you're communicating with a child virtually, and suddenly you're hearing in the background, parents screaming, in these hideous, toxic, horrible way, demeaning way. Well, you might be thinking, oh my God, I'm witnessing this emotional abuse. Well, the fact that it's virtual instruction does not preclude or relieve that teacher from their obligation if they have a reasonable suspicion or belief that this constitutes emotional abuse from doing something about it. Or in the background, they see a parent, slapping a sibling of this student or something, or they see a much younger sibling walking around the background, filthy and filthy diapers, that kind of thing. The fact that you're looking into their home, they're in their home and I'm here, I'd have to report that. That's not the case. The same mandated reporting prerogatives apply. Okay, these are all the different things, assessing supervision. These are the slides I was talking about. These are just indicators of sexual abuse, physical abuse, emotional abuse. And the thing is, if you look over these, they're just they're so extensive. It just take half a day going through these. Some of them are overlapping. What they say could be an example of physical abuse, might also be an example of emotional abuse or medical abuse, that sort of thing. This is not an end all and be all list. This is just kind of sort of things that DCF says you should look for. My favorite, because it seems somewhat absurd, it's so self-evident, is an example of physical abuse, death. Yeah, I think that's pretty unambiguous. But some of these other things, bald patches on the scalp, lacerations of the mouth, lips come to rise. Kids are cutting. Cutting can be an issue. If kids are cutting, that is could be an example of neglect because this is not being addressed, and could trigger the need for a referral to special education, but also could trigger a report to DCF. Okay, let me just do a couple of things because again, good God, well, we're pretty much out of time. Let me just touch upon something very quickly. If I can get down past medical, moral neglect. You never knew why there's so much areas of neglect. I certainly didn't. So why should you make a report? It's the law. And if you don't do it, you're committing a crime. And people might say, but what happened? What will happen if I make the report and it turns out there was nothing there, that it wasn't substantiated? Irrelevant. The process is important. It's not, hindsight is 20/20. And so maybe it's found that there's no substantiation. Like I said, I talked about a case where there's no substantiation, but we still disciplined the teacher because his conduct was just not appropriate. And if you do not make a report, again, you can be disciplined. You can end up losing your job. I was just recently talking to a colleague, as recently as yesterday, about a district in which he works, another lawyer in my firm, and a teacher who was being criminally prosecuted, because 2 years ago he found out about suspicion of sexual abuse and never reported it. So that also goes into the time frame issue. There was a student gave him information which would have led him to reasonably suspect she had been the victim of sexual abuse. He didn't do anything about it, so he was fired because he was criminally prosecuted. So it's very important to the child as well as to yourself. And again, process is important. If it turns out that there's no substantiation, that's fine. That's not your job to decide in the first place whether there's something there or not. That's DCF's job. And the whole point is to let DCF do its job. That's why you report it. Let them figure it out. Your job is to educate. Their job is to investigate. Remember, if you make a report in good faith, you are immune from any civil or criminal liability. If you do it in bad faith, if you know it's baseless and you do it just to stick it to someone, well, no, then you can be sued, and you might also be criminally prosecuted for making a false claim. But if it's good faith, you think, you're not sure, you're not certain, but you really in good faith think there's something there, you're good. Again, you'll be taken off the parents' holiday card list, but and your coworker won't like you anymore if it was a coworker. But you know what? You've done the right thing, and you're immune from civil or criminal liability. And you also cannot be retaliated against for making a report. If you have an administrator or an employer says, "Hey, you're making us look bad by making this report," you cannot be retaliated against. I mean, you can be, I guess, but it's illegal. Ultimately, the DCF Caroline, like you said, well, maybe not a friend, maybe it's more of an acquaintance. But remember, you call them and put it in their lap. You've discharged your responsibility. I'm complying with the law. I'm looking out for the best interest of the kids. I'm looking out for my best interest. I'm looking out for the employer's best interest. I've done the right thing. Now it's DCF's baby. And if they say, "Nah, we're not going to take that up," say, "Okay, I just thought I should let you know your job there is done." And if they do take it up, wow, well, that's a good thing. It's a crime. Remember, you can't just tell me someone else is not sufficient. You have an independent obligation to report. And when in doubt, this is the key takeaway, when in doubt, report. They say here somewhere, you know what? Better to call and have your report go nowhere than not to call and have your career go south. So always, again, the statute is going to be construed broadly in favor of protection. Better to err on the side of caution and to report. Okay, that's about it. There's a picture of me that I hate. I think that's
Mike,
about it. I'm
thank
sorry that I
you,
went over.
Thank you so much. I mean, just such a terrific presentation and
Thank you.
great information. And as you've always, you leave them wanting more. There are a few questions. They're pretty specific and maybe technical. Although this last one, I guess, is interesting. If more than one person got the information at more or less the same time, does each person need to report?
Well, that's interesting. That's a great question, because now I'm flashing back to what I said before, where it says should report or cause to be reported. There's a situation where two people find out at the same time, they both know that each has got the information. So long as say, "Hey, let's go down. Okay, let's flip a coin. Heads, I report. Tails, you report." I'm being facetious, of course. But so long as one of you is making the report, the other one's aware that they're making the report, then that's enough. That you discharge your collective responsibility. If X and Y don't know that the other one knows, yeah, you each have your independent duty to report. And two reports come in, so be it. DCF can sort through it. But if you both find out at the same time, and so long as one of you makes the report and you know that one of you is making the report, you don't just say, "Well, gee, John said he was going to make the report. How did I know he wasn't going to?" I'm talking about situations where you're together and they say, "Okay, I'm going to call right now. Okay, I'm here with you." Hey, I'm going to make a call and I want you to be there with me because I want to make sure I didn't miss anything or forget anything. That's fine. If you do have excuse me, I'm getting choked up. If you do have other questions, my telephone number's there, my email is there. I'm happy to answer questions to the extent that I can. Or if you want me to now, whatever the case may be.
Yeah, there's kind of a one thread of questions about the educational neglect, specifically in this remote learning environment. At what point do you pull the trigger, so to speak? I mean, in terms of making the report to DCF. Go ahead. Sorry.
I'm sorry, Bill. We attorneys like to interrupt people. I think that if it's systemic absences, and if you've tried interventions, tried to work with a parent, and you're getting no response, I think that's when you drop a dime. And
you have a number or a range of absences?
Well, yeah. That's a good point. I say systemic. I don't necessarily mean by that consecutive days, although that's very often the case. But maybe they miss a week, they're there for a couple of days, they miss 3 days, they're there for a day, they miss 4 days. I think that would be sufficient as well. Remember, keep in mind, the State Department of Education is the one that is promulgating these interventions you may want to consider. But that's the State Department of Education. Now over here you have DCF. And DCF says, well, the statutes are what the statutes are, and these are our requirements. And DCF might be a little squishier as well, given that's the virtual learning. They might have the same concerns and consideration as the State Department of Ed. But if you find yourself in a bind with DCF, it's not going to be, I don't think it's going to stand you much stead to say, but the State Department of Education told us that we should be very, very careful about making the educational referrals. You're going to say, well, the obligation is if you have a reasonable suspicion or belief of educational neglect, you got to call us. We don't care what the State Department says. So, I mean, I think you need, just out of common sense, you need to factor in the fact, factor in the new reality and the fact that there could be all these other different things as to why the child isn't coming to school or attending his or her learning. Again, it might be a technological issue. It might be whatever. But once you've reached out and the parent hasn't responded, or nothing, or the parents say, "Oh yeah, we're gonna get right on that," and then nothing happens. I think now you've got reasonable suspicion or belief that there's educational neglect going on, because you've reached out, you've given the parent a lifeline, they haven't availed themselves of it. So I think at that point, it's appropriate for you to call. Again, going back, when in doubt, report.
Right. Well, Mike, thank you so much. Thank you
You're welcome.
for the information. Just so helpful, and I know helpful to the people who are listening today. Quickly, as we wrap up, I want to thank again CAS's corporate partners, Connecticut Army National Guard, Liberty Bank, Horace Mann, Justin's, Connecticut Lighting Centers, Connecticut Department of Public Health, and especially Mike's firm, the law firm of Pullman and Comley. Please look for information about CAS webinars coming up. You can go to our website, CAS-CIAC.org. March 19th, we have a webinar with Tim Salem and library media specialist Janine Johnson from Scotts Ridge Middle School in Ridgefield, exploring ways to use literature to foster conversations around equity, social and racial justice, and cultural responsiveness. Go to the CAS website to register. Check out the CAS News Blast every week for information about our webinars. This webinar was recorded. Anyone who registered will get notification of that. So on behalf of everyone at CAS, I want to wish all of you a great day, great end to the week. Thank you again, Mike. Thank you to everybody. Have a good day.
Thank you. Thanks, Bill. Thanks, everyone.
Thank you, Mike. Really appreciate it.